Our next case for argument will be Republic of Marshall Islands versus the United States. Good morning.
Good morning, and may it please the court. I'm Lori Ashton with Keller Rohrbach on behalf of the Republic of the Marshall Islands, the appellant. Your Honors, the political question doctrine applies to policy choices and value determinations that are not legal in nature. And at the core of this case is a dispute over the nature and scope of the legal obligation to pursue negotiations in good faith under Article 6 of the Non-Proliferation Treaty. And the defendants admit that this treaty is a, quote, legally binding instrument. What we pled and what we know from the legislative history and the drafting history of this treaty is that once it was ratified, it became an inescapable, unqualified, unequivocal, binding legal commitment that certainly became the law of the land. None of these words signify a non-legal, discretionary value judgment. And it is the judiciary and not the executive that says what the law is. Under Count 1, we ask the court to interpret the Non-Proliferation Treaty. We ask the court to interpret this legally binding instrument and describe the nature and scope of the duty to negotiate. Therefore, it cannot be, as the order below would have it, that the legal meaning of this treaty sought in Count 1 is subject to redetermination at will by non-Article 3 officers of the executive.
Counsel, accepting everything that you've said about the treaty being the law of the land, some laws have obligations that are very clearly spelled out, and some don't. So what's the legal obligation here that is spelled out and that you think that we are capable of enforcing? I know you're going to tell me Article 6, so I want you to tell me what in Article 6 creates a legal obligation that you think that we can enforce.
Right, because there are parts of the obligation that would be subject to discretion. But what we pled are only objective breaches of that obligation.
Tell me what the objective obligation is. Tell me what the duty of the executive is. And you refer to Article 6. Right. Tell me what language in Article 6.
It is the obligation to negotiate in good faith. Those four words have a legal meaning.
Yeah, but before that, language is undertakes to pursue.
Right.
That's very, very general sort of precatory language.
I see. Okay, so we cite the court to the Serbia genocide case, an international case from the International Court of Justice, that describes that the word undertakes is a word that's commonly used in treaties and that parties have known for quite some time what it means. And it is a binding promise to undertake. It is unqualified. It is not hortatory.
Do we get, are you suggesting that this case goes forward, that we get to sort of, that we get to ask the executive to open its files to find out whether there's a memo from the Secretary of State that says, gee, we talked to folks in the Soviet Union prior to 1989, and they weren't interested in coming to Geneva. We called India and Pakistan in 1992, and they weren't interested either.
I think it's possible that there would be some evidence that is not accessible under doctrines such as the Act of State. But I think that the answer to your question depends on how the court interprets the nature and scope of the duty to negotiate in good faith.
So what if we were to issue an injunction against the executive? What would we tell them to do?
Right. We would
to undertake to pursue?
Right. The word undertakes, as I stated, has a legal meaning in treaty law. So it means a binding, unequivocal promise. So the order could be that you have to satisfy your binding and unequivocal promise to negotiate in good faith.
No.
So in other words, you have to abide by the
negotiations.
treaty. Is that,
Pardon me?
would we basically say abide by the treaty? Isn't that the essence of what you just said? I mean, what's the difference between saying, well, we order you to undertake good faith negotiations?
Mm-hmm.
All right, you're basically saying we should issue either declaratory judgment or injunctive relief that basically says to the U.S. government, to the executive, get with it under the treaty, under this phrase.
Right. I think before we get to the injunction, we have to define the nature and scope of the duty. For example, we have a very basic dispute with the executive over whether this treaty requires you to attend negotiations. So, for example, as we pled, out of the 190 nations that are a party to this treaty, only 4 of them voted to not attend negotiations, and the United States refuses to attend negotiations, has never attended negotiations. So that's a very basic dispute over an objective matter.
So, so basically, even though the Constitution generally leaves to the executive its execution under the treaties, we would be ordering the executive to attend negotiations. Is that one of the things?
That is one objective factor under the nature and scope of an obligation to negotiate in good faith. There are others.
Well, but I mean, is there there's not a fixed box of what negotiating in good faith means, is there?
There is not a fixed box.
Treaty-wise.
Well, what we cited the court to were examples of...
From labor law.
Not just labor law, also from the state's obligations to negotiate with Indian tribes, also from states' obligations to negotiate the continental shelf, and also the international case law on what that duty means. And in all of those settings, there were not factors in a box that told us what the duty means, but they are all consistent in what the duty means, because this phrase, negotiate in good faith, has a legal meaning.
Well, can I ask this? So this was decided on a motion to dismiss. And if this panel were to say, we're going to reverse and remand to get a fuller record, what fuller record would you expect to be able to collect? So this relates to what Judge Bybee was asking you. Are you going to go and get papers from presidential libraries? I mean, what are you going to do? Most of the documents would have been signed or drafted by people who are dead. President Johnson is dead. President Nixon ratified, he's dead. Probably most of the senators who voted on this. This was a 1970 document, so they're dead. I mean, what is it that if we did say, go and get us a fuller record so we understand what was intended, what would you get us?
I think the answer to your question has at least 2 parts. First, as with any law where the folks who passed it are no longer with us, we have to look at the legislative history. We have to dig into that. We cited several sections in our complaint and in our briefing that tell us that once the treaty was ratified, the obligation to negotiate was unqualified. It was inescapable, unequivocal, binding, and legal. So that has not been controverted by the executive here.
Okay, but my question was, what more would you give us if we did send it back and said, get a fuller record? What would be the fuller record? I understand you gave us some things.
Right. So I think what your question is getting at is the quality of negotiations. What documents would we get to show you?
I'm trying to figure out, is the record we have now the most we're going to get, the best we're going to get on the issue of, what really were people thinking of? Were they thinking this would be a self-executing treaty, for example? I want to know if it's possible that there could be a better record than we have. And if so, what is it that would make it better?
On the issue of self-execution, that is really a separate issue that I'd like to answer.
Yeah, but that's a very important issue to me. So if it were to go back, I would expect a fuller record, if such is available, on whether this treaty was intended to be self-executing or not. And if so, tell me what I might expect to get more than I have now.
In terms of legislative history, I don't know what more you will get. I think we have combed it thoroughly and cited the references to the nature of the obligation. In terms of whether it is self-executing, though, the Medellin case is important here. It tells us that an obligation in a treaty that becomes operative without legislation, if it can become operative, then it has the force and effect of a legislative enactment, okay? So this was an obligation on the executive, which even the other side would agree, is operative without Congress. Congress does not have a right to tell the executive when and how to negotiate. And so the obligation in the treaty, along with the legislative history we've cited, demonstrates that this became operative right when it was ratified.
Well, let's get to Medellin then, because inevitably we need to take a close look at that. So there's some language in Medellin with respect to the domestic effect. Mm-hmm. And in particular, I'm looking at language that basically takes a similar promise as you have here, but then characterizes it as essentially this compact between independent nations. And then ultimately it says it relies on the honor of the governments which are party to it. What do you make of that language with respect to our ability to actually order something here?
Right. Several points on Medellin. First, this was in the context of whether the treaty was operative for third parties to bring treaty claims. So it was not a case between treaty parties. In fact, there is no case suggesting that a treaty party does not have rights immediately. So even if you were to find, which I don't think can be found at this point, that the treaty was not operative domestically, even if you were to find that, there is no dispute that it is operative internationally. In fact, the defendants agree that it is a binding legal obligation. So that makes it different right there from Medellin. We have treaty parties. Secondly, that section of Medellin says ordinarily. And I would submit to the court that it says ordinarily because sovereign immunity is rarely waived and because foreign nations rarely come into our courts, submit themselves to the jurisdiction of our courts for this type of dispute. This is a rare occurrence. And I cited to Professor Damrosch on this point in the briefing.
Counsel, I'm still trying to figure out what Article 6 means. I'm still trying to figure out what you want us to order the executive to do. Is it to pursue negotiations? And then the separate part would be we could judge whether the negotiations were conducted in good faith. So is that the first part is that we would order them to pursue negotiations?
To pursue negotiations in good faith.
So are we instructing them to begin to pursue negotiations? I mean, are we instructing the Secretary of State to call somebody?
Well,
are we instructing them to attend a meeting that's previously been established by other negotiating parties?
It could take either form, Your Honor. I think the first step is to define what the nature and scope of that duty is.
Well, that's what we're asking.
That's what we're trying to figure out. And Counsel,
I mean, do we call up, Dear Secretary Tillerson, you must attend a meeting?
To comply with your obligation to negotiate in good faith, you have to show up. And the United States has never once shown up in 70 years.
So basically we would order the United States through some representative, the executive, to show up at the negotiation.
When is the next
Correct.
meeting?
I can hear people saying that it's in March. That's.
Let's not have the audience participate in the argument, much as you may have some information.
Approximately every year since 2012, there has been a vote in the UN to begin negotiations on nuclear disarmament pursuant to this treaty. The United States votes no, does not attend those negotiations, and puts out a statement saying we're not going to accept anything that happens in those negotiations. So once you define the duty as at least saying you have to show up, which has never happened, then you can decide the scope of the injunctive relief. And
so basically, just to be clear, it would be an injunction or directive to show up at the negotiations, not to say what you would say when you get there.
Certainly not to say what you would say.
But at the very least, we would instruct them not to vote no the next time that it comes up at the United Nations.
I'm not sure you would have to say that they can't vote no, but they would have to attend. So, for example, there were a few countries that voted no and attended and participated. So, in other words, the objective criterion, if we're boiling it down to the easiest and simplest criterion, is that to satisfy this legal obligation, you have to show up, and they have never shown up. I wanted to reserve some time for a rebuttal, but I also wanted to answer for the court any issues you might have on Earth Island. And
No,
then
but my question really goes to whether it's self-executing or not. And so when we're analyzing let's assume that it's not self-executing, just for purposes of talking. Where does that fit either in the redressability analysis or the other construct in which we look at the case?
You want me to assume that it is not self-executing for the question?
Mm-hmm.
If I assume that, then it is at least a binding legal international obligation. And we are here on that obligation if you assume that it was not operative domestically on ratification, which we would argue is contrary. But if you assume that, we are here on a binding international obligation.
So what good what role then would self-executing play? Because virtually you've basically collapsed executing, self-executing and non-self-executing treaties, because, let me just finish the question unless you have an answer before I finish, but essentially, we've made that distinction in the law, and if we take your point, then that distinction becomes irrelevant because every treaty has this overarching relationship between country A, B, and C.
The answer to that lies in the fact that the self-execution doctrine has only ever been applied to third parties. And an international obligation doesn't help a third party because the third parties that have been before the courts are there under domestic criminal law. So it does not help them. It's never been extended to treaty parties. And the reason why it wouldn't is because even if it were not operative, which I claim strongly it is, but even if we were not, we have an international obligation that we can bring before you.
So
if
you're right that this duty to negotiate in good faith, which exists in all kinds of treaties, trade treaties and a variety of other treaties, it would basically mean that all of these treaties would be subject to the jurisdiction of the court without political question or any other disqualifying doctrines, and that a court could direct the executive to get on board with the terms of the treaty. Is that where we would be left?
If there are objective criteria not being met, yes, which is all that we've pled. We have surgically not pled subjective criteria. I would reserve the remainder of my time for rebuttal.
All right. Thank you.
May it please the court. There are a lot of complicated international law and domestic law concepts involved in this case, and before we unpack them, it's important to emphasize one point, which is that the extraordinary nature of the relief that the plaintiff, Republic of Marshall Islands, is asking for here. I mean, a foreign sovereign is coming into a federal court and asking for a declaration that the United States is in violation of its international treaty obligations, and also to compel the United States to initiate negotiations with other sovereign states. That raises obvious justiciability concerns and jurisdictional problems, which we address in our brief. The most obvious one being that the decision-making about when and how and in what context and what time the president, the executive, will initiate treaty negotiations with other sovereign nations is constitutionally committed to the executive branch. It would also, the relief that the plaintiffs are seeking goes against over 100 years of Supreme Court precedent and the precedent of this court saying, and international legal norms, long-standing legal norms that say that when two sovereign nations have a dispute about what treaty provisions mean or whether one of them is in compliance, the way that they resolve that dispute is with recourse to international remedies and not by suing each other in their domestic courts. The plaintiff says that we have conceded that there is a legally binding obligation. What they do not add is that it is a legally binding, it is an international obligation. Treaties bind the nations together with international obligations, and then they contain whatever dispute mechanisms the parties agree upon. So if you look at this treaty, there is no provision for domestic enforcement of the treaty. There is no provision for going into the sovereign nation's domestic courts. In fact, and this goes to your question, Your Honor, about whether or not this is a self-executing treaty under Medellin. So that is one thing that the parties agree upon. Medellin is controlling here. It is the Supreme Court's most full recent explanation of how you determine that a treaty is self-executing. And what the court said was, if it is not self-executing, then it does not have domestic legal effect. And the way that you determine this is you look first and foremost at the intent of the President and the Senate. Because self-executing versus non-self-executing, this is a domestic law concept, not an international law concept.
Can I stop you there just to put some context as you go forward? One of the arguments made is that Medellin came up in the context of a third party, and that the concept of self-executing versus non-self-executing treaties actually has not been tested in the case where you had two treaty parties in contraposition to each other.
Well, the reason for that is that every party that wishes to come before the courts has to have a cause of action. And as we point out in our brief, here, because this is a non-self-executing treaty and there does not happen to be any implementing legislation, there is no legislation that actually gives anyone, including a foreign sovereign, a cause of action to come into court. And so you have to have that. The courts have said, the precedent establishes that even a foreign sovereign needs to have a way to get into court. So if you look at Pfizer versus India, which the plaintiffs rely on, there the question was, did the antitrust laws of the United States, was the way that the cause of action defined, was it defined so that as to encompass allowing a foreign sovereign to file suit? And the determination was that it did. But a foreign sovereign would have to have a way to get into court.
Well, often when we make a distinction, of course, between jurisdiction, which we often look at on motions to dismiss, and then causes of action, are we in a situation under your argument where the cause of action collapses somewhat into redressability? I mean, where does it fit here?
Well, the way that we briefed it was it follows as a consequence of the determination that this is not a self-executing treaty. I mean, because it is a non-self-executing treaty, it has no domestic legal effect. It happens that there is no implementing legislation, and there is no statute, there is nothing that actually gives them the right to come into court. They have proposed that they can come into court directly on the treaty, but there is really no precedent for that. You have to have a cause of action. The APA, we run through the APA, would not give them a cause of action. They do not actually invoke the APA for that purpose. Right. The Tucker Act would not give them a cause of action, although they try to cast this as a type of a contract action. In fact, the Tucker Act or the Little Tucker Act, There are a lot of limitations on bringing a contract action against the United States. You can only get money damages. You can't get injunctive or declaratory relief. You definitely cannot get specific performance. And in fact, an appeal would not be to this court. It would be to the federal circuit.
Yeah.
Right. So it isn't that. So they don't actually identify anything that gives them a cause of action. And that's why you haven't seen a lot of other sovereigns come into court. And also to determine whether, to kind of contest if a treaty is self-executing or non-self-executing. I mean, again, it is not something that other sovereigns would necessarily come into court to contest, because it is a domestic law concept, and because traditionally what sovereigns do is they take their disputes and they settle them in the international sphere. So what
they wouldn't come in to contest it, but the United States would raise it. I mean, that's how it would come up, right?
Your Honor, I can't even think of any cases in which it is hard to think of cases in which a foreign sovereign has come into court, period, about a treaty or about anything else. I mean, usually it is in a commercial context, such as, the Pfizer case.
What if it is self-executing?
I beg your pardon?
What if it is self-executing? Where does that leave you?
Even if this treaty were self-executing, that would not affect the standing and political question problems. Those apply regardless of the status of the treaty as
what would Article 6 have to have looked like in order to be self-executing?
Well, I would be speculating, Your Honor, but I would say...
I'm asking you to speculate just a little bit.
Let me tell you what it would need more than.
If it said, for example, each signatory to this treaty shall attend the United Nations Conference on Non-Proliferation in Geneva, scheduled for every March. They shall send a delegation. Would that, and then shall undertake to negotiate in good faith, but they shall at least attend. Would that be self-executing?
Your Honor, that's a difficult question, because if we look at what Medellin asks, does it contemplate further action? That would still contemplate further action. So I would contrast your example with, for instance, an extradition treaty.
It might at least create a legal obligation to attend something.
An international legal obligation, which is what you have now. But if I can contrast your example with an extradition treaty. Now, of course, every treaty is different and it depends on the language, but typically extradition treaties are viewed as self-executing. And they set out standards. They will say, for instance, X, Y, and Z criminal offenses are subject to, are covered by the extradition treaty. And then that can serve as a rule of decision. So the same for the treaties on inheritance rights of foreign nationals. So those also typically are viewed as self-executing. They don't contemplate require further action by the signatory parties. Here, if we want to look at what evidence we have, you asked what evidence more could be produced. We have all the evidence we need to make this decision. So we have, the legislative history, which is the congressional debates. Sometimes the Senate nowadays includes a statement when it provides advice and consent to ratification. There's no statement. There was no statement by the president in connection with the ratification. There was nothing that indicated that people were thinking that this was going to be domestically enforceable, self-executing. And what you have instead are a number of different statements. We point to them in our brief in the section on self-execution by Senator Fulbright, who was the chairman of the Senate Foreign Relations Committee. And he was responding to a number of different questions. A number of senators were concerned what would happen if Congress passed a law that appeared to contravene this NPT treaty. And repeatedly, he told different senators that it would not be, the treaty would not be domestically enforceable. He did not regard it as such.
So that if Congress passed a law that said no funds, we create the following budget for the State Department, but no funds shall be allocated for the purposes of attending a United Nations Conference on Nuclear Proliferation in Geneva in March. Now, would that create a problem?
Your Honor, I don't know if a funding bill, like simply zeroing out funding for that. I'm not sure what kind of problems that would present. I can say that because we know this from the Earth Island Institute case, that you cannot have a statute, for instance, that says the Secretary of State will negotiate about, and in that case it was sea turtles. Because when a plaintiff tried to sue to enforce that statute, this court said, no, we cannot do that. That is committed to the executive branch. We cannot order.
I think the answer, one of the answers to that is we're not even asking for something as anodyne as negotiating. We're just asking to show up. I think that was one of the things that that she had said. The duty is must attend. So if let's say the only duty they're asking for us to consider here is that the United States must attend these sessions.
Again, Your Honor, we have to look at what they actually asked for in their complaint, and that was to call for and convene negotiations on effective measures leading to the cessation of the arms race and nuclear disarmament. And it is basically asking for an order directing the time, place, manner of when these negotiations will take place, and that is exactly what is committed to the executive branch.
Did we make any attempt to engage in negotiations after this treaty was initially passed? So what, 1969?
Your Honor, I don't want to get into the merits of this. We have strong disagreements with the plaintiff about...
Yeah, I'm just asking a simple question. Have we shown up for any of these conventions?
In fact, Your Honor, every 5 years, and this is set out in the treaty itself, every 5 years there is a review conference. And the review conference, all of the parties meet.
Mm-hmm. Mm-hmm. And the U.S.
There are additional...
And the U.S. has attended these?
Yes. There are additional meetings, as she said, every year or two. On top of that, there are meetings, I think every couple of years, by what is called the P5. And this is, again, it's the nuclear weapon states who are parties to the treaty. The United States does nothing but attend meetings. But that is apparently not sufficient for the plaintiff. They want a particular content. They want a particular result.
Well, they want good faith. They want good faith effort. I think that's what.
Has any administration ever issued a statement on with regard to Article 6, saying that we won't do something, or that it's not feasible to do something, or that it's unavailing to do something, and therefore there's no reason to do it in the future?
Your Honor, I do not know. Okay. That's beyond what I know. But I will say that
there's a bit of a record that administrations, whether Democratic or Republican, have tended to treat their obligations under this in the same way.
That is correct. And also there is a statutory obligation on the part of the Secretary of State, I believe, to certify every year whether or not the United States is in compliance with the treaty. And I believe that has been the case. There has been this certification, and that is another problem that comes up in the context of political question. I mean, we already have the United States speaking on that point, that it is in compliance, and what the plaintiffs are saying is, no, we disagree with that, and we in fact that is unsatisfying, and you need to comply in a different way.
Could I get you into that gets me into the political question issue, and of course we always have difficulty when Supreme Court gives us factors or we make up factor tests. One of the key factors in treaty and other foreign relations cases is that it involves some sort of a sensitive foreign policy issue. So that's what we're usually looking at, but as I understand it, in the district court, the government has said that factor is not in play here. Is that right?
The discussion of that in the plaintiff's papers is not entirely accurate. If one looks at the entire colloquy with the trial counsel, you will see that what he was actually saying was the fact that we are not relying on the fact alone that that this implicates sensitive foreign policy questions. There are all these, it is not a per se, therefore there is a political question. He isn't ruling out that it's part of the analysis because, of course, it goes without saying that the content of negotiations, the determination of when they should take place, whether there should be bilateral negotiations that take place separately, whether there are other issues you want to press with the other nuclear weapon states before you take this on, whether you need to create a context. All of these are the kinds of things that the executive branch must consider in its decision-making. It's a very nuanced determination, and it can't...
So you're basically saying that in the Baker analysis, you would include these foreign policy considerations as one of the reasons that it's not justiciable.
Well, I would certainly say there are decisions that say just the fact that it involves foreign affairs, that's
right.
Not enough, right? Mm-hmm. But what we're saying is it isn't just that. It's that the question about how these negotiations take place, this really is a textual commitment to the executive. There is, a historical gloss on, the Article II powers saying that, the president, the executive has to speak with one voice in conducting diplomatic relations, in conducting these negotiations. And so it isn't simply that it involves foreign affairs. It is that there is a whole package here. And also that to get into, if I have enough time to talk about very briefly the absence of any manageable standards, a number of your questions seem to me to raise that problem that a district court would have to evaluate, just looking at the text of Article 6, what does it mean, undertakes to pursue? What does it mean to pursue? And what kind of negotiations are sufficient negotiations?
So counsel, there are provisions of a treaty that might be self-executing, while other provisions might not be self-executing. So under Article 1, each nuclear weapon state party to the treaty undertakes not to transfer to any recipient whatsoever nuclear weapons. Is that self-executing?
Your Honor,
the U.S.
I have to admit,
transfer nuclear weapons to another country.
I have to admit, Your Honor, that although I've read the entire treaty, we did not focus on whether that portion was self-executing. So all I can speak to is whether Article 6 is self-executing, and we believe it is not. The plaintiff has also made some points about good faith and arguing that that the court should resort to relying on cases under the Indian Gaming Regulatory Act and the NLRA. Those statutes in which contain that standard, they actually have some provisions that give content to the standard. And that brings you back to the fact that here you do not have a statute. It is the absence of the statute that makes the distinction. And in fact, that is a distinction in many of the cases on which the plaintiff relies, in which the Supreme Court did not find that there was a political question. So, for instance, in Japan whaling, the court said this is simply construing a statute. Or Zivotofsky, on which the plaintiff relies, the court said there's a statute and we can construe it. And it is significant that in Zivotofsky, when the court went on to construe the statute, when it returned to the Supreme Court said, well, this would violate the clause about recognizing foreign governments, and so it cannot be enforced. So, which is essentially, what we're saying here is, if there were a statute, you would not be able to enforce it, just as Earth
is that
Island.
Is that aspect of the Baker criteria of lack of manageable standards tied in then to execution and self-execution in your view?
Even if, Your Honor, I think even if it were a self-executing statute, even if it did provide it did have legal effect, you would still have this problem. You would have a treaty with legal effect but no standards.
Well,
because again,
that goes back to I think we're kind of talking to a degree past each other between the parties, because they say, yes, it does have legal effect. And you say, well, yes, it does in the international arena, but not in the domestic arena. So we're looking, each side is saying it has legal effect, and if it has legal effect, the U.S. courts can interpret what does that statute mean, or what does the treaty mean?
Well, so let's say that I see my time is up, but if I can answer
Please.
your question. So let's say that they actually did pursue international remedies. And as in fact they have, they've gone to the International Court of Justice. I do not think they have received a satisfactory response from the International Court. But let's say that all the parties were hypothetically amenable to jurisdiction, and this question went before the court. The International Court of Justice could look at its past cases, which are not precedential even to itself, but they could look at those cases as to how it has interpreted in an international context that good faith obligation, right? So there it's relevant, but it is not relevant domestically. I mean, here what they are pointing toward is, case law involving a good faith obligation that specifically derives from statute, which gives it content. And here we don't have anything domestically that is giving content to this treaty, to those words in this treaty. So it would be an unmanageable standard. It would involve a lot of guesswork about kind of very subjective evaluation on issues that are committed to the executive branch and are very nuanced. I mean, it would be a very blunt instrument to take the NLRA standard and try to use it in the context of diplomatic negotiation and what is acceptable.
Thank you.
Thank you, Your Honor. We ask this court to affirm.
Your Honor, when treaty parties want to resort to outside jurisdiction, want to limit recourse to negotiations, they do that with language in the treaty. For example, in the NATO SOFA treaty that is referenced in the Holmes v. Laird case that is in the parties' briefing, a 1951 treaty, they have a provision that says all differences between the contracting parties relating to the interpretation or application of this agreement shall be settled by negotiation between them without recourse to any outside jurisdiction. That's how treaty parties preclude outside jurisdiction when they choose to.
And if they
But that's
don't have
what
that clause, then you're sunk?
No, I'm distinguishing this clause from a self-executing analysis which has never been applied to a treaty.
Well, all that does is basically give you, in effect, what she was referencing is it gives you a standard for resolution in the international context, doesn't it?
It gives you at least that. I would submit to you that any holding saying that the executive's obligation to negotiate was not operative on ratification would contradict the only Senate history that's in the record, and that is that this treaty certainly became the law of the land on ratification.
Well, that's true. Is that not true of every treaty?
Well, no.
It does become the law of the land. I mean those are the terms that are used to describe generally what treaties are, right?
I think what the government has argued here is that this treaty did not become the law of the land, that it is only an international obligation.
The Constitution is also the law of the land, but there are provisions of the Constitution that are non-justiciable.
Right.
So the fact that something is law doesn't mean it's justiciable in Article III courts.
Right. I'm only addressing right now the self-executing question as opposed to the political question issue.
Okay.
Okay. I would also like to direct the court's attention to the Japan whaling case, which counsel mentioned. In particular, please note that the relief requested by the plaintiffs there was an injunction against the executive to negotiate with Japan. They wanted an order saying that the executive could not negotiate with Japan any different whaling quotas. It was specifically a limit on the negotiating power under Article 2, and that did not transform the legal analysis into a political question. So the fact that this injunction is sought does not transform the case into a political question. Additionally, the word undertakes, this was alluded to earlier in Medellin, was found to be more general, and that makes complete sense because the United States was undertaking in Article 94 of the UN Charter to comply with ICJ judgments. But our executive in the United States does not have the power to change state criminal law remedies. So it makes sense that that would require additional legislation because the executive lacks that power. But the executive distinctly has the power to negotiate. So, and the government has never put this forward, it does not make sense to say that you need legislation to empower the executive to negotiate, because the executive has that power. It is distinct from the Medellin holding. The review conferences that Council alluded to that occur every 5 years do not satisfy the Article 6 obligation to negotiate in good faith. In response to an earlier question about what additional evidence you would see declarations on that point. It has never been suggested that the Article 6 obligation to negotiate in good faith can be satisfied by showing up to review conferences every 5 years.
Well, let me just go back to your question about your statement that even if it's not self-executing, about the good faith. I mean, nothing would preclude if the United States signs an agreement that ends up in an international treaty and it has a good faith obligation in it, whether it's self-executing or not, nothing would preclude the executive, would it, from deciding it wants to go out and negotiate?
Nothing would preclude the executive, that's
right.
Correct.
So it doesn't matter in terms of what the executive might want to do as to whether it's self-executing or not, right?
I would disagree with that because the doctrine of self-execution revolves around whether a treaty provision is operative.
Right.
Whether it operates with respect to the party before the court. This provision, Article 6, certainly operates. There is no third party coming in here and saying, I claim third party rights under this treaty, and that promise operated to protect me, therefore I can be here. That's why that doctrine has never been extended to a treaty party. For example, in the Washington versus Washington fishing case, this is a 1974 Supreme Court case, I believe it's in the papers. The United States filed an action against the state of Washington seeking declaratory and injunctive relief on the meaning of a treaty. It was a treaty with an Indian tribe. The United States had standing to go in and seek that declaratory relief and that injunction, and also at issue in that case was a treaty with Canada, and the court had to decide whether that treaty affected the treaty with the Indian nation. And there's no issue of self-execution there because it's a treaty party coming in to enforce a treaty right.
Thank you. I'd like to thank both counsel, both for your briefing and for the argument. Excellent in a difficult case, and also we also thank the multiple submissions of the amicus briefs. The case just argued is submitted.